It is.
Good morning, everyone. Thank you for joining. This is the legal webinar series. We try and do about 6 of these a year. This topic is hot topics from the Legal Hotline. So basically, I just talked to the Legal Hotline attorneys and asked them what are the top questions you're getting, and that's what this webinar is based off of. So I do have a PowerPoint, so let me switch over to that. Okay, as far as questions goes, I will try to answer any questions as we go along after sort of each topic. If I do not get to your questions, I apologize. We only got an hour for this. And quite frankly, some of these topics, I could probably spend an hour on each and every topic. So I can't get to everything, but what I don't get to, keep in mind, we have over 400 FAQs on our website. That are some of these topics that we'll discuss today are on those FAQs. And obviously, since this is the hot topics from Legal Hotline, you can always contact the Legal Hotline. Okay, here are the topics. Here's what we'll be discussing it again, based off of the top 10 topics, top 10 questions that we get on the Legal Hotline. So let's jump right in with the first topic. If the seller learns of new information about their property after providing the seller's disclosure notice, does the seller have a duty to provide the new information to the buyer under the current contract? Absolutely. Sellers are required by law to disclose any material information, even if that change came after they've previously provided the disclosure notice. Now, this isn't coming from the property code, so you're not going to see it there. This is case law. So these are lawsuits that have been filed and judges who have made their ruling, and that now becomes a law and how we have to do things. And this is, you see at the bottom of this screen, there's the update to seller's disclosure notice. That's a new-ish form, maybe a couple years old, that Texas Realtors put out, and it basically just has a bunch of blank lines at the bottom to say what new information that the seller wants to give. Now, this is specifically within the same transaction. If a transaction came, it fell through, and now you got another offer coming in, the seller should go ahead and fill out a new seller's disclosure notice with whatever new information that the seller has. So this one is particularly within the one transaction. Okay, I'm just checking questions here, see if we've got any questions on that one. Moving on to the next slide. Do we have a binding contract, or when is the effective date? These are kind of the same type of question that we get, and it's generally about contract formation. Do we have a contract? If we do, what's the effective date? When does it start? Okay, just reading, excuse me for a minute, checking up on the chat and the questions. What about seller refusing to get the inspection report? That kind of gets into the weeds, and if you get me talking about that, it might be 10 minutes before I finish talking about that. That's a good one for the Legal Hotline. Okay. All right, contract execution. This box here You might recognize it. It's from page 8 of the 1 to 4 family residential contract, and it instructs the broker to fill in the date of final acceptance. If you pay real close attention to this box, you'll see a bunch of different words. First word is executed in all caps, and then you write in the date, and then in parentheses, you got effective date. And then at the bottom, it says broker fill in the date of final acceptance. All of those are the same thing. For this contract, the date that it is executed is the effective date, and that is the date of final acceptance. So it's a bunch of different words that all mean the same thing, that all refer to this one important date. Okay. So how do you determine when, if the contract is binding? When does it start? What's the effective date? It's the date of final acceptance. And that is the day the last party to sign the contract, to accept the contract, communicates that acceptance to the other party. It's the date of that communication happens is the date that the contract officially becomes binding. That is the effective date. And that's the date that you start counting all the other time frames and deadlines, all the 3 days after the effective date, 10 days after the effective date. That's the date. It's the date the communication occurs, which may hopefully is the same day that that last person signs it. But if for whatever reason there is a delay, if let's say the typical transaction, the buyer is the one who submits the offer, signs it, sends it over to the listing agent gives it to their seller, they sign it, and then the listing agent will communicate back saying, yep, signed, we got a date. If there's a delay, it's the date that the actual communication occurs. Not necessarily the day it's signed, but the day that the communication occurs. Couple related issues with the same topic. What happens if the broker doesn't fill in the effective date? Still got a binding contract. Okay, the broker forgetting to fill in this date does not stop the contract from being executed. It's an executed contract once the last party signs it and the communication occurs, binding contract. Another related issue, buyer doesn't deposit the earnest money, right? I hear this question a lot. The earnest money is not consideration for the contract. So you do not have to have the earnest money to have a binding contract. It is a binding contract before the buyer deposits the earnest money. If the buyer does not deposit the earnest money, they're in default of an executed contract, and then seller can, choose their remedy. But you still have a binding contract, even if the broker forgets to fill in the final date of acceptance. You still have the executed contract without the earnest money. Okay, so a few questions pop up. Someone says the last party does not have to send a copy of the actual contract for it to be effective date. No, not really. There's no legal requirement for that to happen. Obviously, the buyer wants a copy so they can see for themselves, but no, that's not the date. It's the date that the communication happens. Are sellers required to turn over previous inspection reports that they listed in the disclosure? That's a tricky one. They're not required to actually turn over the inspection report, but sellers are required to disclose the information. If it's a material information, they are required to disclose the information that's contained in those reports. So obviously the easiest way to do that is to just give a copy of the report, but they're not legally required to hand over an actual copy of the report, just the information contained. So it says, what if all parties have verbally agreed, but contract is being revised and all signatures have not been completed? That's going to be the statute of frauds. Remember, this is a real estate transaction. It has to be in writing and signed. So verbal agreements, verbal acceptance does not count, not with a real estate sales. It has to actually be in writing and has to be signed. So verbal agreements don't count. Okay, getting some long questions in there in the chat and the Q&A. Let me try and move on. I want to make sure I get through all the slides in the hour. I will try and come back to some of those questions later on, but let me try and move on. We got a jam-packed hour of information right now. All right, this one deals with the option fee. Can the seller terminate because the buyer didn't pay the option fee on time? No. The seller cannot terminate because of the option fee. The only consequence that the buyer suffers for not turning or paying the option fee on time is that they would not have the unrestricted right to terminate under paragraph 23. All right, still a binding contract. That is different than the way the earnest money works. There's a lot of confusion because they both have that 3 days to pay time frame. And so the different rules kind of get jumbled up amongst each other. If the buyer doesn't deliver the earnest money, the seller can terminate. But if buyer doesn't deliver the option fee, the buyer just does not have the right to terminate under paragraph 23. That's it. Other related issues, option fee is paid to the seller or the seller's agent, not to the title company. And at this time, I will bring up, you guys may have heard, TREX Broker Lawyer Committee. They've got some big changes to the 1-to-4 contract coming up in a few months. And one of those changes is the option fee will be paid to the title company. And I know a lot of people are saying, well, we've always paid it to the title company. Well, you weren't supposed to. The option fee was currently supposed to be paid to the seller or the seller's agent, not to the title company. That's changing. Those new changes are coming. They're pushing for February for the new changes. We'll see. I don't want to get too far in the weeds with the new contract. Trust me, we're going to do big things when the new 1-to-4 contract comes out. We're going to probably do a whole webinar just on the changes. We're going to put magazine articles. So we're going to go really in depth on that. So I don't want to go too far in that. But for now, the option fee is supposed to be paid to the seller, not the title company. The other most asked about question regarding this is there's a lot of confusion with the 5 p.m. deadline. The 5 p.m. deadline in paragraph 23 only applies when the buyer is sending the notice to terminate. It does not apply when the buyer is paying the option fee, paying the option fee within 3 days. That is not a 5 p.m. deadline. Okay. In fact, the only deadline in this entire process that actually has a time of date is that one situation. Okay, the 5 p.m. deadline only applies to notices. If you take a look at paragraph 23, right in the middle, there's kind of a red highlight around the word notices. That's the paragraph. That's the key paragraph. Notices under this paragraph must be given by 5 p.m. local time. Notices, that's it, not the paying of the fee. The notice under this paragraph is when the buyer notifies the seller that they are terminating under this paragraph. And it's not any other notice either. So it's not if the buyer is terminating under third party financing, that does not have a 5 p.m. deadline, only this one, okay? Someone asked 3 days for delivery of the option fee, but Sundays and holidays don't count for calculating earnest money. That's not quite right. It's 3 calendar days, but only if the last day falls on the weekend or the holiday. Then you keep going forward until you get to a non-weekend holiday. So you still count it. So if it's executed on Friday and you're counting the 3 days, execution day is 0. So Friday is 0, Saturday is 1, Sunday is 2, Monday is 3. So it would still be due on the 3rd day. And that's the same with the earnest money. So you still count weekends and holidays. It's only if the last day falls on it do you move forward, but you don't skip them when you're counting the 3. Someone says for buyer's termination of the contract, I'm assuming that's talking about the 5 p.m. deadline. Again, if the termination is under paragraph 23, it's 5 p.m. deadline. Any other termination of the contract by the buyer, we all know there's all sorts of ways for the buyer to terminate. All the other ones do not have a 5 p.m. deadline. If it doesn't have a 5 p.m. deadline, you have until the entire day to send whatever notice, which means 11:59 p.m. Okay, getting a lot of good questions. Unfortunately, I need to move on to the next topic. Those are great questions for FAQs or the legal hotline. All right, intermediary. A lot of questions on intermediary. Does a listing broker have to act as an intermediary if an unrepresented buyer is interested in their client's property? No, they don't. The broker may represent the seller only. There's no law that requires a buyer be represented in the transaction. They can be an unrepresented buyer and the broker can just represent the seller. If that's the case, brokers should make it clear that their duty is only to represent the seller. Make that in writing. We do have a form that can be used, the representation disclosure. That's TXR 1417 in our list of forms. But if on the opposite end, if the broker does want to be the intermediary, here's how it's done. Keep in mind, there is no dual agency in Texas. They have replaced it with intermediary. So if you've got the buyer and the seller, this is how you got to do it, or the landlord and the tenant, but primarily this comes up with buyer seller. Only the broker can be the intermediary. Sales agents, you cannot be an intermediary. We get that call a lot from a sales agent say, well, I'm the intermediary, and we have to pause and say, well, no, you're not. Only the broker is the intermediary. Then what the broker can do is they can appoint sales agents to either side. So one sales agent to the buyer, one sales agent to the seller. So basically you need like a pyramid. You need 3 people. You need the broker as the intermediary and a sales agent on either side. And it could be an associated broker as well. Broker cannot appoint themselves to one side. So you need at least 3 if you're going to appoint people to one to represent the buyer and the seller. So sometimes that means that somebody might have to give up a client. So if a sales agent has both a listing and the buyer, once it turns into an intermediary, the sales agent is going to have to give up one of those so that the broker can appoint another sales agent to represent them. Once you make an appointment, You can give all the advice and opinions to your client, the normal range of your services you can give to your clients. If no appointments are made, the broker and none of the sales agents can give advice and opinions. And those two words are directly from TREC rules. No advice and opinions can be made. So basically, you're just kind of shuffling paperwork back and forth. Someone's asking if there's two brokers in the company, can you have intermediary? Well, you can have lots of people with, brokers, but one person is the broker for the company. They're the intermediary, and you need at least two more people to appoint, one to the buyer, one to the seller. So if it's just the two brokers, you can be intermediary, you just can't do appointments, which means you can't give advice and opinions. If you want to give advice and opinions to the clients, you need at least three. The broker, the one responsible for the company, will be the intermediary, and two others will be appointed, one to the buyer, one to the seller. Someone asked, what if the broker is representing the seller? Does the broker need to appoint to another agent? Yes. If the broker has one of the client, they're going to have to remove themselves to become intermediary and then appoint sales agents to either side. The broker cannot appoint themselves as one of the sides. Now, this is if you want to give advice and opinions. If you don't give advice and opinions, you don't have to make appointments. And the broker can keep their client and the agent can keep their client, but now you're limited because neither can give advice or opinions. So it's probably not going to be the level of service that you're used to giving if you don't make appointments. Okay, someone asked about intermediary without appointments. Again, the only thing is you can't give advice and opinions. And everybody in the firm has to follow that rule. So nobody can give advice or opinions to the clients if you don't make appointments. Okay, I still got a lot of questions coming on. I'm going to have to move on. Okay, for the Seinfeld fans out there. Yada, 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 who gets the earnest money? Earnest money disputes. This question comes in lots of different forms, and there's usually a very complex backstory behind it, but in the end, it's who gets the earnest money. Unfortunately, this one depends. And we on the Legal Hotline, we cannot act as arbitrators or mediators. We're not judge and jury, so we can't give a ruling on who gets the earnest money in your specific transaction. So what we do is we generally point you to different areas of the contract to look at. In some cases, the terms of the contract will determine who gets the earnest money. If the buyer terminates under the option period of third party financing, the contract specifically says buyer receives the earnest money. If you're not talking about a specific or specific term in the contract where it says who gets the earnest money, then you kind of fall under the default paragraph. That's paragraph 15. And whoever's not in default, the non-defaulting party, has three options. The first one is they get to terminate and receive the earnest money as liquidated damages, or they get to sue for specific performance, or they get to seek other relief as provided by law. That basically means they get to sue somebody for damages. Now, sometimes you're going to fall into a situation where somebody just, they're being a jerk and they're refusing to sign the release of earnest money. And then the title company is not going to release it without both people signing. And it's clear that, you know, they don't get the earnest money. They're just mad that the way it went down. Seller's mad that the buyer gets to terminate after they've taken the property off the market for a few weeks. But the contract says buyer gets to terminate, and the seller just says, well, I'm not signing it. Well, unfortunately, it's a contract. It is binding. Buyer and seller have made promises to one another, but there's no magical properties that will actually make a party physically do what they're supposed to do. So sometimes, I mean, disputes happen. Sometimes someone actually kind of knows they don't really have rights to the earnest money, but they're just being difficult about it. But sometimes it's a genuine dispute. Both parties think that they're in the right. I generally point to paragraph 18, the escrow. Paragraph 18D specifically talks about damage. Any party who wrongfully fails or refuses to sign a release acceptable to the escrow agent within 7 days after the request, they could be liable for damages, the earnest money at issue, attorney's fees, and cost of suit. So there is, you know, nobody likes to sue. Nobody likes to go to court except for us, the attorneys. But everybody but the attorneys, nobody likes to go to court and fight over these things. But there's a little bit of light in that if a party is just absolutely refusing to sign and the title company won't, that the person who then has to file a suit, you're going to get paid back. You're going to get the earnest money, you're going to get damages, you're going to get attorney's fees. So this is a good paragraph to send to the other side if you're dealing with somebody who's just kind of being difficult. It's like, well, look, if you're going to be difficult and this has to go to court, we're going to get the earnest money anyways, plus you're going to have to tack on attorney's fees for it. If it's a case where both parties kind of legitimately think they're in the right and they don't want to give it up, you know, that's when it's time to start negotiating. If you can negotiate something, even if you think you're right and you should get the earnest money, sometimes it's easier and quicker to negotiate, split it some type of way, 50-50, 80-20, 75 to whatever, and be done with it and move on with your lives. Let's see, someone says, is damages 3 times the amount, 3 times the earnest money? Not anymore. I can tell you've been around there, Thomas. That was the language a while ago. That's been changed a long time. It used to be that the damages were automatically 3 times the earnest money, treble damages, as they used to say. That's been replaced for a good while with this paragraph. So basically, instead of automatically getting 3 times damages, you have to sue somebody and you have to go in and you got to prove what your damages are. So you don't just get automatically 3 times. Okay, let's see. Just reading through some of your questions. Someone says, if terminating under paragraph 23, do you have to get a release of earnest money signed or just the termination of contract? That depends on the title company. I know some title companies, if it's clear that the buyer had the right to terminate under the option period, that they do not require a release of earnest money. Basically, the title company, they don't want to get sued just like everybody else. So they're fearful of giving the earnest money to the wrong person. So that's why they typically require a release of earnest money be signed by everybody before they release it. They don't want to be in the position of deciding who gets it and who doesn't. But in a clear-cut case of like the terminating under the option, I do know of some title companies that will go ahead and release the earnest money back to the buyer if it's clear that they are terminating within their rights. Someone says, where can I get the document these paragraphs come from? This is in the 1-to-4 contract. Paragraph 18D is in the 1-to-4 contract. Somebody says, what happens with the earnest money when nobody signs and nobody sues? It sits at the title company for a while, for a few years, and then there is a provision in state law that it will eventually go to the state of Texas. That takes a while though. That takes a few years before it comes to that. Can the property be placed as active while the earnest money issue is resolved by courts? Joe, there is no law that prevents it. But from a risk reduction sort of point of view, that's a risky move for the seller to move on like that. Because that previous buyer that's in the dispute, they might decide that they're going to file a lawsuit over it. And if the seller has moved on and they're under contract with somebody else, and now here comes a previous buyer filing a lawsuit, that's going to be risky for the seller. So the sellers, from a risk reduction standpoint, should do whatever they need to do to clear up that old earnest money dispute and get it done, release of earnest money, so they can move on with their lives. Okay, Ronald, that's sort of the same answer. Contract has been terminated, but earnest money is in dispute. Can seller accept and close another contract? Same answer. It's just nothing legally prevents it, but it's risky. And keep in mind, if there is a previous earnest money dispute, a lot of title companies, most title companies, don't even want to open up a new title because of that previous earnest money dispute. So that's going to be sort of a roadblock for a seller trying to move forward without getting that previous earnest money dispute cleared up. Okay, let me move on, everybody. If the backup contracts, one of the more confusing aspects, the backup contract. If the backup contract never moves into the primary position, is the backup buyer refunded the earnest money and option fee? Yes to the earnest money, no to the option fee. The earnest money does get returned to the backup buyer, but the seller keeps the option fee. We get a lot of questions about this. Some, I'm not sure if it's a confusing issue or if people just don't like it and disagree with it. But even if the backup buyer never moves into the primary position, yes, the seller does keep the option fee. The reason being is that the buyer is paying for the option to terminate. They're not paying if they terminate. They're not paying to terminate. They're paying for the option to terminate. And when a buyer is in the backup position, they have the option to terminate. Even if they don't exercise that option, if they sit there and just ride it out, waiting to see if the primary contract is going to fall through, they still had the option to terminate. They don't get it back if they did not choose to exercise that option. And I think some of the confusion comes from some people think that the backup contract is not an effective contract until or unless they become primary, and that's not true. The backup contract is a binding, effective contract as soon as it is signed and, date of final acceptance, all of that. It is a binding contract, and the buyer does not have a right to just back up and leave before their primary position. The only thing that allows the buyer to just up and leave is the termination option under paragraph 23 of the 1-4, and you have to pay for that. Reading the very first line, that the paragraph A, that comes from the backup contract. Very first line, the contract to which this addendum is attached, the backup contract, is binding upon execution by the parties, and the earnest money and any option fee must be paid as provided in the backup contract. That is the within 3 days language. Those are the only two things that the buyer has to do with a backup. You got to put in the earnest money, you got to put in the option fee. After that, it's basically you just hit the pause button. And then the buyer doesn't have to do anything after that. Seller doesn't have to do anything after that. And you're just waiting to see if the primary contract falls through. A lot of questions about how to try to change the way this works. There's a whole nother slide about special provisions and about trying to change the way that this works. Be very careful about that now. If you just don't like the way that it works, like you understand it, you just don't like it and you think it should be different and you want to change it, it's going to take an attorney to do that. Or you can talk to TREC to see if they will change how the backup contract works. But this is the way it's written. The backup contract addendum is written by TREC's broker lawyer. And if you go trying to fiddle around with it and trying to make it work differently, it's sort of risky. Earnest money, does seller need to sign release of earnest money to release the earnest money back to the buyer? Probably not, because that's one of those, remember the title company, they're worried about being sued. Well, if it's a backup contract that never became primary, I mean, the seller has no rights to the earnest money. Okay, let me check a few questions here. Okay, Teresa, great question. So if the backup contract says we have 7 days for option period, when do these days start? Okay, here's how the option period works under a backup contract. The way it's written in the actual backup contract is kind of confusing, so I'm not going to read that. I'm just going to explain it. The backup buyer, once they pay for the option period, you have the option the entire time that you're in the backup position, regardless of how long it is. So let's say you write a 7-day option period. You sign the contract, the backup contract, you're in the backup position for 3 weeks. You got the option to terminate the entire 3 weeks, regardless of those 7 days. Once you become the primary contract, then you get an amended effective date. The original effective date was when you first went under contract. Once you become primary, you have an amended effective date. So that date is now the effective date that you start counting all the days. So you have 7 days after that day for your option period. So the entire time you're in backup, regardless of how long it is. And then once you become primary, that's when you start counting the number of days that you wrote in the contract. So you almost get 2 option periods in one. Someone asked, shouldn't a release of earnest money be signed regardless of earnest money delivery? Yeah, the release of earnest money, it also has release of liability. So both parties are saying they're not going to come back and sue each other. Yeah, it's still a good idea to get the release of earnest money signed. But someone asked, do you need it to actually get the earnest money back? I would think most title companies would give it back anyways without it. But because of those additional releases of liability, it's still a good idea to get a release of earnest money signed. Oh, sorry, let me go back. Let's see, regarding backup offer, when you're in a backup position and the earnest money and option money have been paid, can the buyer back out during the waiting period? Yes, that's what you're paying the option money for. When you're in the backup position, the buyer can terminate under paragraph 23 when they are still in the waiting period. Okay, a lot of great questions. I'm falling behind. Let me move on. Sorry, guys. Okay, quick property management question. The tenant asked for the carpet to be replaced because it looks worn and needs repair. Is the landlord required to replace the carpet? Under this scenario, no. Neither the Texas Property Code nor the residential lease requires the landlord to replace or repair something like this. Texas Property Code section 92.052 requires a landlord to make a diligent effort to repair or remedy a condition if the condition, and these are the golden words, materially affects the physical health or safety of an ordinary tenant. That is what a landlord has to repair under Texas law. Other than that, the actual language of the lease can also require a landlord to make repairs. For example, the Texas Realtors residential lease is written to be in compliance with the property code. So if you follow the lease, you're going to be in compliance with the property code. The residential lease, Texas Realtors residential lease, also says specifically that the landlord will pay for heating and air conditioning systems, water heaters, or water penetration from structural defects, whether or not they materially affect the physical health or safety. So you don't even need to get into that. The lease says that the landlord's going to pay for that. The residential lease also says that the landlord will not pay for items that are cosmetic in nature, such as the carpet being worn and discolored. Now, if the carpet is so bad that it's torn up and may pose a tripping hazard, now you might be getting into materially affecting the physical health or safety of an ordinary tenant. And yes, it does use the word materially affects. There's no laundry list of items that need to be repaired or not repaired. The landlord is the one who makes that call. What materially affects the physical health or safety. That's the landlord's judgment. From a risk reduction point of view, if it's a close call, might be better to go ahead and repair it, landlords. Because you might say, oh, that doesn't materially affect, but if the tenant challenges you and you're sitting in front of the JP and the JP says, oh yeah, this materially affects, now you've got some penalties you're going to have to pay. So when it's a close call, whenever you see the words like materially or reasonable, something like that, risk reduction says, go ahead, close calls, go ahead and take care of it. What is an ordinary tenant? That's the same type of question like materially affects. There is no standard. Basically, that's there so that if somebody has some rare issue, that the landlord is not required to go above and beyond the call of duty to fix something because somebody has some type of rare condition, so that the landlord doesn't have to put in a $10,000, air purifying machine in the house because the tenant has severe allergies. Okay, moving on. And I will try and go back through, if we get done early, I'll try and go back through and try and catch some of these questions that I'm skipping. But I do want to get through all the slides and then I will go back through some of your questions. Okay, commissions, specifically commissions when an agent leaves a brokerage. One of my agents left my brokerage with a pending transaction. Do I still owe them a commission when the transaction closes? Okay, this one I have to give the most typical of typical attorney answers. It depends. I know you guys love that answer. You sit and you call the legal hotline and you ask your question and then the lawyer says, well, it depends. But this one truly is. There is no universal rule that covers this. There's no TREC rule. There's no state law. This one is 100% what is the agreement that brokers have with their sales agents. It depends on the agreement. Texas Realtors, we do offer an agreement for this. It's called the Independent Contractor Agreement for Sales Associates. It's form number 2301. But even in this one, just to show you how wide open it is, that's the line at the bottom of the screen, paragraph B. Any fee to associate that remains unpaid on the date of termination will be paid in accordance with the attached fee schedule. Or number 2, a completely blank line for the broker and the sales agent to come to some type of agreement. It's completely wide open to whatever the agreement is. Hopefully, you guys have those agreements in writing. Sales agents, hopefully you have written agreements with your broker. Brokers, if you do not have written agreements with your sales associates, shame on you. The independent contractor agreement, it covers not just commissions when someone leaves, but all sorts of scenarios dealing with commissions. What happens if someone leaves and you have to transfer their pending transaction to another agent? Who gets paid what? The written agreement will say that. For some of you and maybe the large franchises, I know they probably have their own, agreement with sales associates. Take a look at those, because this answer really depends on whatever agreement you have with the broker. All right, special provisions. And we get this question many different ways, but it really boils down to this question. I want to protect my client. So can I write in special provisions, and then they tell us whatever it is that they want to write in special provisions, and we give them the same answer pretty much every single time. I'm gonna just let that sink in for a minute. So before, when people were asking questions about the backup contract and, oh, can't we just put in special provisions that the buyer doesn't have to pay the option fee until can we do that? Here's the answer to that question. This is really about the unauthorized practice of law. as real estate agents and brokers, to be honest, you're put in sort of a tricky situation. You do get to fill in the promulgated form for your clients, but you cannot write a contract or a paragraph in a contract or even a line in a contract unless you are a licensed attorney. So we got TREC Rule 537.11B that specifically prohibits license holders from drafting language defining or affecting the rights, obligations, or remedies of the principals of a real estate transaction, including escalation, appraisal, or other contingency clauses. You got Article 13 of the Code of Ethics that generally just says realtors shall not engage in unauthorized practice law. But that's what the danger is when you start fiddling around with special provisions. Okay, the actual language on the paragraph special provisions, I didn't put it up here, but I think you guys know it. It's, only write business details or factual statements. And we get a lot of people who try to just label whatever they want to write in there as, oh, this is just a business detail. I've seen like whole contractual provisions written in there, and then someone tells me it's just a business detail. Well, it's not what you call it, it's what it does. If you're writing anything in special provisions, that changes the way the contract works. So if the buyer can do something under the contract and then you write in special provisions and now the buyer can't do it, that's not just a business detail, that's your drafting language that defines or affects the rights of the principals. And it's a potential TREC violation, it's a potential Code of Ethics violation. It's actually also against the law as well. Texas law says no unauthorized practice of law. And because this one is so tricky, because there is no laundry list of things that you can write or not write, it's like walking through a minefield. You don't know where the trouble is, but you step on it and then it goes off. It's like, oh, I wasn't supposed to step there. The way to do this, the way to actually get something in special provisions, it's about who's coming up with the language. That's what drafting means. Who's writing, whose brain did the language come out of? If the language is coming from you, the realtor, the agent, the broker, that's when you're in danger. That's when you're walking through the minefield. If the language is coming from your client or your client's attorney, that's safe. Your client, because they are a principal, they can write whatever they want to write in their contract. That doesn't mean it's a good idea. If they don't have any type of legal experience, they can do more harm than good. But legally, can your buyer, your seller, give you language and say, put this in my contract? Yes, legally, they can do that. It's better for you to say, go talk to an attorney if you want to change this. And then get that language from your client's attorney, get it in writing, and then you verbatim put that language in there. That's the safest way, and you get all of that in writing. You get the language in writing, you get the fact that you advise them to go talk to an attorney about it in writing. Email is fine, text messages are fine, but that's the safe way to do it. But if you as an agent broker starts coming up with the language that you're going to write in special provisions, even if it's for your client to protect your client, that's when you're in the danger zone of unauthorized practice of law. Okay? Someone asks, what is the intent of special provisions? And I get that. Like, if we can't write in it, what is it for? Well, the intent of special provisions is exactly what you think it's for. It's when the client needs some special language that the contract doesn't cover. The only issue is who's going to write that special language. That's where the problem comes in. But it is for what you think it's for. Examples to special provisions. Okay. Can you write provisions? What if a realtor and you own the property? Two other points. One, unauthorized practice of law deals with you writing a contract for somebody else. If you are a party to the contract, then unauthorized practice of law doesn't apply. So for brokers, your buyer rep and listing agreements, you are a party to the contract. You can write in special provisions all you want to. Now, legally, you can write in special provisions all you want to. As an attorney, I feel obliged to say, still get the advice of legal counsel before you start changing the contracts. But legally, as far as unauthorized practice of law, are you clear to write in special provisions when you're a party? Yes, you can do that. And someone says, I usually get, what can you write? Usually nothing that's going to do a lot of good, like informational type of stuff. Like in my subdivision, I've got those the mailboxes that are, not in front of the house. They're off on the corner, like the apartment building of mailboxes where there's like 50 in one spot. They don't have the address, is obviously for security purposes. They've got some different kind of code on it. When I first moved in, the owner didn't tell me what the code was. So I had to go and I had to figure out which box was mine. Now, if I wanted to sell, I can put in, or an agent can put in special provisions. The mailbox number for this property is 1751. Completely, totally informational. Doesn't change any rights. Nobody has to do anything differently. Nobody's prevented from anything, purely informational. That's the kind of stuff that you as an agent on your own can write in special provisions, purely informational. If it's going to change anything about the contract, you need to get that language from your client or from your client's attorney. Okay, guys, let me move on. Got a few more questions to go to. My buyer is submitting an offer above the list price and is willing to bring extra cash to closing if the property doesn't appraise. What form do we use? All right, this one is the form with the award for the longest title. Addendum concerning right to terminate due to lender's appraisal. It is form number 1948 on our list of forms. We get a ton of questions. This is another new-ish form. Came out, I guess, a year or two ago from Trek. So instead of a specific question about it, I'll just kind of generally go through the whole form. It's really just these three questions, and we always get, I don't know what these three questions or these three provisions mean. What do they do? What's the difference? So I'll just kind of generally go through all three of them. One of the confusing things is this is really like an addendum of an addendum. So this only works with a third-party financing addendum. Okay. It does not work with cash deals. If you got a cash buyer and they want something like that, don't go writing in special provisions. They need to talk to an attorney to get some type of language that does something similar to this. And then you get that language straight from the attorney, and then you can write it verbatim in special provisions. But this only works in conjunction with the third-party financing addendum. Specifically, if you look at paragraphs 1 and 2 waiver, here, let me jump over to, here's the third-party financing addendum, paragraph B. This is what is being changed. So, you got paragraph A, which is the buyer getting approved. That deals with the buyer's credit and their income and stuff. And then you got this language, paragraph B. Property approval. If buyer's lender determines that the property does not satisfy lender's underwriting requirements, for example, a low appraisal, then the buyer gets to terminate. And then there's the rule, 3 days before closing, you got to get a letter from the lender and all that. But basically, if the property doesn't appraise, the buyer gets to terminate. That's what it boils down to. And it is that right to terminate that the buyer can waive by checking box 1 or 2. The buyer is saying, even if the property doesn't appraise, doesn't meet lender's underwriting requirements, I will still buy the property. And I will bring cash to close, extra cash to close above and what I've already said in the contract in order to make that happen. That's one. And number two, the buyer is waiving their right to terminate under the Third Party Financing Addendum, paragraph 2B. The difference between 1 and 2 is that number 1 waiver does not matter. There's no limit. Doesn't matter how low the appraisal goes, and it doesn't matter how much more cash the buyer has to bring. The buyer's got to still buy the property and bring that much cash to close. If the buyer doesn't, buyer's in default. Okay. Obviously, make very sure that your buyer understands the financial implications of checking box number 1. Box number 2 does the same exact thing, except the buyer and seller can agree for a limit. That's what that line, the 2 I's, the opinion of value is X or more. The buyer can set a limit of how low the appraisal goes, and they will still buy the property. But if the appraisal goes lower than that amount, now the buyer regains their right to terminate under third-party financing. So they're partially waiving as long as the appraisal is this amount or over. If their appraisal is lower than that amount, buyer gets their right to terminate under third-party financing again. Okay, so that's number 1 and number 2. Number 3 is the exact opposite. Number 3 is an additional right to terminate. In addition to buyer's right to terminate under third-party financing, the buyer may also terminate the contract if the appraised value is less than X amount. So basically, the buyer is saying, I want to buy this property, but I want to make sure it's going to appraise to the value that I want. And if it goes under this, then I have a right to terminate. That is a separate and distinct right to terminate for low appraisals. That's a little bit different than the third-party financing right to terminate. And a lot of people are confused with this one because they believe that the third-party financing already did this. Couldn't you already terminate for low appraisals under third-party financing? And I think that's where the confusion comes in. Back to third-party financing property approval. Look at the language very closely. It does not say if the property doesn't appraise, the buyer gets to terminate. It says if the buyer's lender determines that the property does not satisfy their underwriting requirements, the buyer gets to terminate. So third-party financing is all tied to what the lender decides. So it is not an automatic that when the property doesn't appraise that the buyer gets to terminate under third-party financing. Okay, paragraph 3 says that automatically. If the property is appraised under that number that you guys insert, the buyer gets to terminate. Who cares what the lender is going to do? That's the difference between these two. It's possible that there might be some overlap, that if the property is so low, if box number 3 is checked, that the buyer automatically gets to terminate from the low appraisal. But under third-party financing, it's possible that the lender also says that doesn't meet our underwriting requirements. So it's possible that the buyer might be able to terminate under both, but they're doing different things. So that's why it's called an additional right to terminate. And there was a little hole that was discovered in third-party financing. And I'll give you a quick example. And I'll keep the numbers kind of even so I don't have to do a lot of tricky math. I went to law school, I'm not a mathematician. So if a property is under contract for, say, $100,000, the buyer is going to put a big down payment. That's where the hole comes in. They're going to put 20% down. So they're going to put $20,000 down. They're going to finance, get a loan for $80,000. Let's say the appraisal comes in at $95,000. It's $5,000 less than what the buyer's paying for. And the buyer goes, oh, low appraisal, I get to terminate. Oh, hang on a minute. The lender is the one who needs to make that determination. The lender is going to look at it from the point of view, well, I'm only loaning you $80,000. And the property's valued at $95,000. The lender could very well say, well, that meets my underwriting requirements. I'll still loan you $80,000 on the value of $9,000. That meets my loan to value. Now I'm making these numbers up, so any mortgage people on there, don't put in the chat that my numbers are off. I'm making it up. But if the lender makes that call and says, I'll loan you $80,000 off of $95,000 value, the lender is still loaning the money. The buyer would not have a right to terminate under that scenario. So it is not automatic that a low appraisal automatically the buyer gets to terminate. It is based off of the lender's underwriting requirements. And so paragraph 3 was created to fix that hole so that the buyer and the seller can agree on a specific appraisal amount, that if the appraisal comes in lower than this, the buyer gets to terminate, period, regardless of what the lender says. Okay, and that's it for my slides. Thank you very much for attending the legal webinar series, Hot Topics. If I did not get to any questions today, I sincerely apologize. We only have an hour. And like I said, I could probably do an hour on all 10 of these questions. If you do have any burning questions that I didn't get to, the legal hotline is available Monday through Friday from 9 a.m. to 4 p.m. We have 3 full-time attorneys that are there to staff the legal hotline to answer all of your questions. And I saw a lot of questions in the chat that they would be perfect for them to answer. And with that, I say thank you and goodbye.